Welcome to Q&A practice. We'll start with the plaintiff. Ready? Do you have any idea whether the inventors, Richard Ryan and Ron Kang, would have reviewed the patent application before it was filed with the U.S. Patent and Trademark Office? I don't remember. That's going back a while. Understood. Okay, Steve. What I've just put before you is Deposition Exhibit 13. Looking again in the upper right-hand corner, it's U.S. Patent Number 254218C1. Is that fair? Yes. And again, the inventors on this one are Richard Ryan and Ron Kang. Is that correct? Yes. And as you previously testified, Richard Ryan, at least at one time, at the time of this application, was an employee of Ryder North US. Is that fair? That's fair. And Mr. Kang, at least as of the time of this application, was an employee of Ryder North China. Is that fair? That's fair. And the filing date on this is September 12, 1999. Is that fair? No. Oh, I'm sorry, looking at the wrong one. It's the date that the application for this patent was filed was October 3rd, 1999. Is that fair? That's fair. And again, looking down that column number under references cited, the second patent listed is 21845521. Is that correct? That's correct. And again, I'll represent to you that that is the patent at issue in this case. Will you accept that? Yes. So based on Deposition Exhibit 13, would you agree that somebody within the Ryder North family of companies was aware of the patent at issue in this case, at least as of October 3rd, 1998? Same objection as before, calls for speculation. I don't know. Do you know whether Richard Ryan or Mr. Kang were involved in the design or manufacture of the products at issue in this case? I don't recall. This is back to 1998. Given that they're inventors, I would assume so. What were their positions to the best of your knowledge? Mr. Kang, I don't remember his exact title, but he was in R&D, and Richard was on the legal side. Was he an attorney? Yeah, I believe so. So I take it, based on the fact that, is it Mr. Kang, Ron Kang? That's a man, isn't it? That's a man, correct. Let me back up. I take it based on the fact that Mr. Kang was in R&D for Ryder North China, you would conclude that he was involved in the design of the products at issue in this case. Objection as phrased calls for speculation. I don't know if he was involved in the design. I'm not sure in what part of R&D he was involved, but he was likely involved in some part of the design or manufacture of the products at issue in this case. Same objection. I don't know. Do you know whether either Ryder North US, Ryder North China, or Ryder North Limited, or anybody within those entities first became aware of Wilton products? I'm not sure when that would have been, but at some point somebody did become aware of Wilton products. Is that correct? I would assume so. Do you know whether any Wilton products were purchased by anybody within the Ryder North family of companies? No, I don't. Okay, I've just put before you Deposition Exhibit 14. The first email in this email chain is Deposition Exhibit 14, is from Mr. Lee to somebody named Bob on May 22nd, 1999. Is that correct? Yes. Do you know who the Bob is that's referenced to in the Deposition Exhibit 14? I'm not sure without a last name. Could it be Bob Reynolds? I don't know. Do you know when Ryder North China, Ryder North US, or Ryder North Limited first started selling the products at issue in this case to Walmart? You don't have to speculate. There's documents that verify it. I know. Yeah, if you don't know for sure. I don't know for sure. stop there and do some practice with our other transcript. And we'll start with the plaintiff. Ready? Did they tell you that there was drug trafficking in the area? Yeah, there was. They told me that there was drug trafficking. I said, well, not when I'm working anyways, not when I'm working. And that's why I was very concerned. And that's when I started getting nervous. And I think with the cue stick, I used to knock on the bars, I guess, to make sure that when is your best recollection of when the police would come by or came by to kind of give you a little warning of illegal drugs in the area? No, they didn't give me a little warning. They told me straight out. Oh, what did they say? They told me straight out that they got a call, and there was a call that they were selling drugs in the bar. Oh, in the bar? Okay. And then I say, no, they don't. Okay, when did that happen? I don't remember. Okay, I really don't. Do you know if it happened last year or the year before? No, this year. Happened this year. Oh, it happened this year in 04. This year or last year? I don't remember. No, I don't think. Last year. Okay, last year. All right. Yeah, because I've been gone for 7 months. Last year, excuse me. All right, last year makes sense. When you worked there, did you become aware that on last year, 2004, towards the end of the year, November, do you remember hearing that the police had come into the bar and made some arrests? Yes. All right. Yes. Were you still working at that point? Yeah, I was working. Okay. All right. And when you, at that point in your mind, when the police came and said there was a drug problem there, was that before? Oh, way before that. Oh, way before? Way before that. But then when I see people, strange people that come in and out, I think, I can't tolerate that. I tell them to leave or to stay out or to whatever. So when the police told you of this problem, did you just tell them that you didn't see anything? Or no, I told them I didn't see anything and I would not, Okay, no further questions. Any redirect? No. Thank you very much. You may step down. Did you want any of these witnesses that have testified to stick around, or are they excused? They're excused as far as I'm concerned. All right, you can leave if you'd like. Thank you. May I just have a moment with Mr. Van? Yes. Do you have any other witnesses, Mr. Crane? No. I did propose a stipulation to Mr. Van. He questions whether it's relevant or not. I said I could make an offer of proof as to what the stipulation was, depending on your decision. If it's not relevant, then no. If it's relevant, then he will stipulate. So on that basis, what I would like to do is just, tell you what I would propose to do. I would offer a stipulation that the subject license that we're talking about currently in the county of Los Angeles, where this is located, has a market value of somewhere between $85,000 and $90,000, and the purpose of doing that is because the department is seeking. That's the proposed stipulation, and I'm just going to tell you why I believe it's relevant. The reason that I believe it is relevant is the department is seeking the penalty of straight revocation. We recognize there are some issues, and we believe that revocation, which may be mandated under the Act, takes several forms, and that is revocation stayed to prevent transfer to persons double transfer, revocation stayed with number of days. I mean, there's a number of forms of revocation, and we believe that in light of the mitigating factors, which the evidence has come out, that the ultimate penalty has a significant financial burden. And I realize financial burden is not typically a consideration, but in this instance, I think in determining the subject penalty and perhaps option of straight revocation, it does have a bearing, and so that's the basis. And that will conclude our Q&A practice.